So thank you for the invitation. I'm really happy to be here with you today and also to have the chance to share with you some insights of the Italian system and our approach to the protection of unaccompanied minors, and especially on the issue of age assessment. So let me share the presentation. I'm gonna share the screen so that we can start. Sorry, just a sec. Okay, here we are. I don't know whether or not you can see the presentation. I will also start it. Okay. Can you see it? Yes, I think so. Well, I don't hear anyone, but I hope so. Okay, yeah, great, thanks. Okay, so yeah, once again, thank you very much for inviting me. I really look forward actually not just to share our experience as Italian lawyers, as ASG, our association, on the protection of unaccompanied minor, but I'm also eager to listen from you about your experience. So what happened in Poland, what are the main challenges, what are the differences, and how you approach this topic of protection of unaccompanied minor and the age assessment procedure. So I would like to organize this 1 hour and a half that we have together in the following way. First, I will try to give you a brief overview of the Italian law on unaccompanied children in order to give you a little bit of context of the Italian situation, of the many laws that have been adopted in a few years. And also, I would like, at the end of this brief presentation, to underline the main challenges, so the main critical issues related to detention of minors and age assessment. And secondly, if we have time, but I hope so, I would like to carry out a slightly more practical activity. So my idea was to present you some case studies, and we can use those case studies to discuss together some issues, and maybe even to analyze how then the courts reacted and the decision adopted by courts in these cases. So let's start from the Italian context. Our conversation begins in, let's say, 2014, 2015, in a period when, okay, sorry, I hope everything is still fine. Let me continue. So our conversation starts in 2014, 2015, a period when the number of unaccompanied foreign children grew consistently in the country. For many children, as you might imagine, Italy is one of the first country of entry. And so during those years, the numbers of unaccompanied minors increased consistently. And then we are witnessing somehow similar challenges in the last 2 years, especially in 2022, because of the high number of unaccompanied minors from Ukraine. And so this year again, we have witnessed an increase of these numbers. And together with the increase, some quite worrying phenomena took place. One of them being the disappearance of minors. For example, in 2014, 2015, there was a huge difference between the number of Eritrean, Somalian, Afghan, and Syrian unaccompanied children arriving by sea, and those reported to be in the childcare system, in the reception system. So it appeared clear that they often disappeared even prior to the inclusion in the mainstream child protection system. Similarly, like another similar phenomena is the one of so-called children in transit. So those children disappeared while after they were already accommodated in reception centers, but because of they wanted to move, and most of the cases they wanted to reach their families or their communities in other European countries, quite common phenomena was that they left the reception centers shortly after their accommodation. So maybe after 1, 2, 3 weeks, they left, trying to move to other countries. And while it's definitely understandable that these children wanted to move towards their family ties, to being more in contact with their communities of origin, on the other side, when Italian authorities try to analyze this phenomena and to understand the reasons behind these high numbers of disappeared children, one of the challenges, one of the problems was identified in the ineffective system of protection, especially the ineffectiveness of the immediate and first care reception center and accommodation, as well as of the system of appointments of guardians. So at the time, again, from 2014 to 2016, there was no consolidated law related to the protection of unaccompanied children. So the applicable provision had to be found in the general juvenile law. However, there was no specific guarantees for migrants. And another quite important, quite relevant issue was that there was no centrally coordinated reception system, as well as no central database. And so all the municipalities, all the local actors acted on their own. So it was very difficult to reach a coordination between also different institutions, because there was the local municipalities together with the representative of the Ministry of the Interior, so what we call prefectura. So there were many actors that acted in very different and not coordinated way. Moreover, in 2014, the European Commission started an infringement procedure against Italy. And among the contested violation of the directive on asylum procedures, so at the time was in Italy, we implemented Directive 2003/95. One of the problems was that the Italian system failed to grant both an expeditious and an adequate procedure for the minors seeking international protection. And also connected to that, there was a failure in granting high standards of conditions in reception centers. So against this background, let's say two new laws, one on asylum procedure and the other one on unaccompanied minors, were developed. The first one in 2015 and the second in 2017, but they were developed, let's say, at the same time. So the idea was to create also coordinated system of protection, as it was lacking actually. So these laws innovated the overall system of protection of unaccompanied children by acknowledging the need of central coordination and introduced specific rules and safeguards for the protection of this specific category. So before delving into the specific issues of age assessment, I would like to here I wanted just to underline some of the main risks for fundamental rights and the main violation we actually witness of children's fundamental rights. So because of also a lack of a protective, adequate legislative legal framework, children often were accommodated with adults. It happened that they were detained, and it was more likely that they were subject to violence, exploitation, trafficking, or forced labor. So these were the main challenges, the main issues that the new law wanted to tackle. As for the reform, just to mention the key points of the 2017 law, the so-called Zampa law on accompanied foreign minors, I just wanted to underline the most important aspects, and also the fact that all these provisions were grounded in the principle of the best interest of the child. The first article of the law opens with a statement about the importance of considering in all procedure the best interest of the child, which is something that was never clearly stated, at least in the law before. And so the best interest of the child principle also became a legal standard for the judiciary to assess every protection and accommodation measures, and also to assess the lawfulness, for example, of age assessment procedures. And so as for the main key points, it's important to underline that unaccompanied minors were defined as a vulnerable subject. And this was valid for all unaccompanied minors. So not just for asylum seekers, for example, not just for victims of trafficking, but every minor, every unaccompanied minor on the Italian territory is considered as a vulnerable subject. And therefore, he or she needs to be protected. What's the practical implication? The implication is that even if unaccompanied minors, they don't apply for asylum, for example, they are entitled to a permit to stay. So they are regular on the territory. And secondly, which is strictly connected to this, the idea, the consideration of minors as vulnerable, we found a clear statement in favor of the principle, the application of the principle of non-refoulement. And some special rules about return. So principle of non-refoulement meant that the law stated a clear prohibition of returning migrants, unaccompanied minors at the border. So minors can never be pushed back at the border. And also, as far as the return is concerned, there are some strict rules that only allows return when this is in the best interest of the child. And basically, it's very rarely implemented. So as a general approach of the Italian system, an unaccompanied minor cannot be returned. It follows from that, the very important implication of the principle is that unaccompanied minor cannot be detained either. So nor, of course, they cannot be detained during the return procedure, because there is no return procedure against, so no return order is issued to unaccompanied minors, but they cannot be detained during the asylum procedure as well. Because also under the legal framework regulating asylum procedure, minors are targeted as specific vulnerable groups, and therefore vulnerable groups cannot be detained. So there is a general prohibition of detention for children that then also extended to children with families, because of the many safeguards for children in general. So generally we can say that children cannot be formally detained, legally detained. Then, as we will see at the end of the presentation, there are several problems related to de facto detention, but I will come back to that. As for the other most important elements of the law, we witness so the procedural guarantees for the identification and determination of age were definitely innovated, and so there were found some more precise and accurate guarantees, whereas before we could only find general guarantees applicable to individuals and not specific for unaccompanied minors. And then there has been also an innovation in the procedure to appoint a guardian. So in line with the request by the EU to grant expeditious procedure within a specialized system, the competence for assigning a guardian to unaccompanied minors was moved from the general court to the juvenile court. And so right now, only juvenile court can appoint guardian. So it's a faster line, let's say. Also very important is that the law established that minors have the right to be appointed a guardian as soon as possible, including in cases when the age is contested. So if, as we will see in a moment, actually, as soon as there are doubts about the age of the minor, a guardian shall be appointed. And finally, guardians are no more only those appointed within the social services of the municipality. So before the 2017 law, this role of guardian was only provided for representatives of social services, so representatives of municipalities, of institutions. After the law, a new idea of guardianship was developed, as guardian can be anyone from the civil society. So there is this new figure of volunteer guardian, and basically it's normal people from civil society who volunteer. They have to attend a training course, of course, but then they can be assigned to one by one. So each minor is appointed with one guardian, whereas before the situation was that there was many unaccompanied minors for only one guardian, because the guardian was the representative of the municipality. So especially in the southern region, one guardian had the guardianship over 100 children. And then the system changed a lot, and it's definitely much better now. So we have really seen the difference. And finally, the last point, because I just wanted to let you understand how the system changed, how much the system changed. The law, both 2015 law on asylum procedure as well as 2017 law on unaccompanied minor, changed completely the system of reception, which is now tailored on unaccompanied minors. So basically the reception and accommodation system is divided into two phases, into two stages. During the first phase, children are accommodated in first reception facilities with the purpose of providing first aid and immediate assistance. So children should stay in those first reception centers only for a few days, and the maximum is 30 days. These centers are run by the Ministry of Interior local representatives, so the prefectura. And during this phase, children are identified. They have to be informed about their rights, including the right to appeal for asylum, the right to apply for asylum, and age assessment procedures can eventually take place. One quite important point to be underlined is that while it's very important that the age assessment take place as soon as possible, so as soon as doubts about their age arise, at the same time, what happened in the past was that all the age assessment procedure were initiated starting were initiated by the courts in the southern region, where migrants were immediately accommodated after search and rescue and after disembarkation. And this created quite an important burden on those courts. There were, let's say, 2-3 courts that had to be competent for many procedure of age assessment. And this created quite few delays in the procedure. And so what changed is also that with the new reception system, these first accommodation centers were located within the entire territory. So the idea is that when minors are rescued in the sea, and then they are disembarked, and then they are immediately moved to the first accommodation centers within the entire territory. So the idea was to find a more balanced distribution of minors within the territory. The second phase of reception and accommodation should take place inside, in accommodation and integration system. These centers are run by municipalities, and they have to comply with the standards of assistance of the general the mainstream childcare system. So the idea is that from the very moment that minors enter the SAI accommodation and integration system, they are treated equally as Italian, so as national minors, especially with regard to access to school, to professional training, to healthcare, to medical and psychological support, and to labor eventually. So there is a principle of equal treatment. The problem, so the system in theory, it's quite advanced. The problem is that as a general rule, children should remain for a very short time in first reception facilities and then immediately be transferred to SAI facilities, to the second stage. However, there are, one of the main problems of the system is the lack of places in SAI. And this has resulted over the years in longer periods spent by minors in extraordinary or first reception centers where they do not have access to adequate inclusion and integration services. One of the reasons why there are not enough places in the SAI system, in the second phase system, is that the municipalities, so the institution in charge for activating the SAI projects, there is not an obligation to do that. So they may activate SAI project only on a voluntary basis. And so there are several how can I say, it's quite, the system is not, there is not a uniform distribution of places within the SAI in the national territory, even though I must say that with the last year, with the Ukrainian war and the refugees from Ukraine, many municipalities were more willing to activate SAI project. And this also can have a benefit consequence on children in general, because of course it will not be possible to discriminate between Ukrainian children and non-Ukrainian. So the idea is that maybe in the future there will be more places available for children. So this was just an overview of the main innovation brought about by the Law 47 of 2017 and of the reception system in Italy. Now, before moving to understand the Italian framework on age assessment, I would like to point out the main references, the main principles that the Italian legislator looked at when drafting the law concerning age assessment. So of course, the principles are the international law principles, and it also was very important to look at the European standards. And one of the main relevant documents to this regard was the EASO 2014 publication on guidelines on age assessment practices in Europe. Exactly because it provided a useful overview of the main issues on the way other European countries tackle the issues, and also on the EU principles on age assessment. So that publication was quite important in guiding, in influencing the Italian legislator when adopting the new law. So what are the main principles stated by the EU instruments and that we can find in the 2014 EASO guidelines? Of course, first of all, we find the best interest of the child that has to be applied at least in 2 moments of the age assessment procedure. First of all, the best interests need to be taken into account when deciding whether or not to undertake the age assessment. So as we will see, age assessment should not be a routine practice, and it should only be activated, it should only be carried out when there are serious doubts concerning the age of the person. And so when deciding whether or not to conduct this age assessment, the best interest of the child has to be taken into account. And second, it also influences the methods used in the age assessment. Another connected principle is that the methods used in the age assessment procedure should be as less intrusive as possible. So, for example, it's important to consider first the general statements, the declaration of the minor, and other relevant information, and especially other relevant evidence, if there are some, before proceeding to intrusive medical examination. Then, of course, among the most important principles, we found the right to be heard, the right to participate in proceeding regarding the age assessment, and the right to appeal the proceeding. So also this is quite closely connected to the right to have access to a representative and to lawyers. Then one of the central principles, which is very important, as of course also for our system, is the one of the benefit of the doubt. As right now, there is no current method of age assessment that is able to determine a specific age with certainty. So therefore, during the entire process, but also at the end of the process, if doubts remain as for the age of the person, the individual should be treated as a child. And this was, in many cases, this principle was not applied, especially during, as I said, 2015 and 16. But the fact that it was included in the new law, it gave the possibility to judges to actually sanction the case in which the principle, the benefit of the doubt was not applied in the single case. Again, as for the methods, the idea, the suggestion coming from EASO are to adopt a multidisciplinary approach, and so to combine different methods. I will not delve too much into the different methods that we have. Of course, I'm aware that you know very well that there are non-medical methods as well as medical methods, and even within medical methods, there are many different ones. We can find psychological examinations, psychiatric exams, psychiatric tests, and of course, we also find pediatric observation, including X-ray. And even among X-ray tests, there are so many. So for example, in Italy, as we will see, the main method used is the X-ray of wrist and hand, but there are many other, the X-ray of collarbone or dental X-ray. And for each type, as I said, there are different methodologies applied. So I will not go into the details of this method, but what it's important to underline, also we found that in the EASO guidelines, as I said, is that there is not only one method that should be applied. So there is, of course, no method can tell us with certainty how old someone is, especially after, at the end of the growth of the child. And so it's important to combine all these methods, and to improve the reliability of age assessment, the inclusion of different social, psychological, and medical methods, it's very important. And this is also in line, allows for the method to be in line with the principle of the best interest of the child. So those were the main principles that I just wanted to recall the fact that both under the European Union legal framework, but also under the Council of Europe guidelines, we found very similar principle. And actually, as you can see from this slide, once again, this is a publication from the Council of Europe, and it stresses the importance that no single age assessment method can give at the exact conclusion. The best interest of the child has to be central, and once again, the benefit of the doubt principle. So these were the principles that the Italian legislator tried to adopt, try to implement within the Italian legal framework. And just to give you a more, just to let you understand how much the law changed before and after 2017, I wanted to present you some of the provision that mention the age assessment before 2017. So basically, we found the mentioning of this procedure, as I said, not in a general law, because there was no general law on unaccompanied minors. So there was no single and comprehensive law for an accompanied minor, but there were many differences, many different provisions regarding asylum seekers, victim of trafficking, and we also, at the level of guidelines, so not proper law, but more guidelines, the Ministry of Labor and Social Policies developed some indication. So before 2017, age assessment was mentioned only in these, let's say, three main instruments. In a legislative decree, in a law on asylum procedure, that said that in case of doubt about the age of minors who applied for asylum, the individual may be subject, with his or her consent, to non-invasive medical examination. And then the law also provided for a right to be informed about the methods used and also the consequences of the age assessment. Most importantly, the law stated that refusal to undergo the examination did not constitute grounds for not granting asylum. And this is also very important because as we've seen from the European and international principle, amongst the guarantees, there is also the need to inform minors and to acquire, to get their consent. But of course, they are also free not to consent to undergo, to be subject to this age assessment. And this should not have consequences in terms of asylum application. So rather the reasons, the explanations for why the minor decided not to take this procedure should be carefully analyzed and taken into account. So we can see from this initial provision that there was only a mention of non-invasive medical examinations as a way to conduct age assessment. And that's the only method mentioned before 2017 for asylum seekers. So this is only valid for a specific category of an accompanied minor. And then again, there was a quite advanced law in terms of guarantees for victims of trafficking. This is included in a legislative decree of 2014 that implement 2011 directive on victims of prevention of trafficking human beings and protection of the victims. And here we see that we found a mention of a multidisciplinary procedure to be carried out by specialized staff. So a more detailed provision on how to implement age assessment. And what's quite important is that the law also mentioned the fact that pending the age assessment and the identification procedure, the victim of trafficking should be considered to be a minor, both to regard to assistance, so general assistance, for example, healthcare and general services, and to accommodation. So victims of trafficking should be accommodated within specific accommodation centers for minors. And the guidelines, 2013 guidelines, also reiterated, actually, well, they were developed before 2014, so before the adoption of the law on trafficking. And they already stated the idea of the principle of the doubt. So that the need to presume the minor age of the person in case of doubts. So this overview is just to let you understand that we had, before 2017, we had some provisions on age assessment, but only targeted specific categories. So for example, if an unaccompanied minor reached Italy and he didn't want to apply for international protection, he was not qualified or identified as a victim of trafficking, it was very difficult to find the specific and adequate procedure to be carried out. And this is also due to the fact that the Italian Supreme Court, the civil court, stated that because some juvenile courts, some judges, they try to extend by way of interpretation these principles also to unaccompanied minor who didn't apply for asylum, were not victims of trafficking. So many decisions of the judges on the merit try to extend these guarantees, but the Supreme Court stated that it was not possible because the law was very clear and only targeted some categories. So this is why Law 47 of 2017 is so important, because basically it filled this gap, introducing provision on the age assessment, general provision, so valid for everyone. We also need to I just want to recall that in those years, the practices were quite problematic. In fact, unaccompanied minor arriving in Italy with no identity documents systematically undergo the age assessment. And this age assessment usually was carried out mainly with medical examination. So basically it was only based on X-ray of the wrist. The margin of error was hardly ever indicated in the results. And so basically the benefit of the doubt cannot be applied. So we see that all the principles we have named so far were not applied in practice. Whereas after 2017, things began slowly to change. And that's because the target, the main idea of the law was to protect children, irrespectively of their migrant status. So irrespectively of the fact that they were asylum seekers, of the victim of trafficking, or minors who were entitled to a permit to stay because of the fact that they were underage. So the same rules apply to everyone. Once again, of course, the principle of best interest of the child, we already underlined that. One of the important provisions of the law was also the obligation to immediately appoint a guardian. So after the arrival of migrant, and in some situations even before starting the age assessment, so immediately after the initial interview, the appointment of guardian had to be implemented. So how does it work in practice? What are the steps of the age assessment procedure? So first of all, as soon as a minor, a contact is established between the minor and Italian authorities, so mainly border police or in general police authorities, social services or representatives of local authorities, minors should be subject to an interview. The interview, so the aim of the interview is to assess the individual personal and family history, and to delineate, to find the main elements relevant for his or her protection. So the idea of this interview is to understand what are the needs of the child. For example, to evaluate whether or not he or she wants to apply for asylum, to evaluate whether there are indicators that the person is a victim of trafficking or a victim of torture. So to assess the needs of the person. So, and this is not an age assessment interview. While of course, during this first phase, doubts might arise as to the age of the minor. And so this is the initial step after which an age assessment procedure can be activated. And then, according to the ZAMPA, to the 2017 law, one of the main principles is that to determine the age of the person, the first way it's through documents, so through identity documents. And when there are some documents, and among the documents, we include the passport, of course, but also identity card issued by the country of origin, and even eventually a birth certificate issued by the country of origin, as far as it has a picture in it. So as far as it's possible to identify the person by looking at the picture. So if we have all these documents, the age of the person is the one stated in the documents. And so there should not be any further assessment. In case, but of course we all know, I'm sure you are all aware that most of the cases, minors want to apply for asylum and maybe they don't have documents with them. And so in this situation, if there are doubts, the next step is to activate the formal procedure. That means that the police, for example, police authorities or even social services cannot ask for social or medical exams to take place. They have to inform the juvenile court, and precisely the prosecutor at the juvenile court. That's the only institution that can start formally activate an assessment procedure. And so everything has to happen within the judiciary system, because that's the place, that's the situation in which minor can be fully guaranteed. So it can have access to the whole range of guarantees. And so the procedure is opened by the prosecutor, who is the one that orders medical and social examinations. So the element of the age assessment, sorry, I cannot, yeah, here we are, sorry. So the main elements of the age assessment are social and medical assessment, social and medical exams. And according to the article of the law, they have to be conducted in an appropriate environment, and we will see in a moment more specifically what are these places. It has to be carried out through a multidisciplinary approach, and again we will see in a moment what's the meaning of this concept of multidisciplinary approach, and by adequately trained professionals at the presence of a cultural mediator. So this idea to always have a cultural mediator among the professionals in charge of age assessment, it's very important. I think it's crucial to our system, and we have noticed as lawyers, as legal professionals, the difference that the presence of a cultural mediator makes. Because to have a cultural mediator is not the same thing as to have an interpreter. For example, an Italian interpreter that can translate from French or English or Spanish into Italian. The cultural mediator has another role because it's the bridge between the culture of the person, of the minor, and the Italian professionals. And so we really have noticed how important it is. And the last element, the last requirement of age assessment is that it should use the least invasive methods possible, and it should respect the person's sex, presumed age, physical and mental integrity. So those are the elements of the age assessment, and they're not just, what I want to underline is that they're not just something stated into the law, but judges, when they have to evaluate whether or not the age assessment is lawful, they need to take into account all these elements. So if the age assessment was conducted by a trained professional, but without the presence of cultural mediator, it's possible to appeal against it, to ask for a review of the assessment. These are the elements, but of course, the way and the approaches followed by different institutions still were quite different within the territory. So even after as I said before, the introduction of 2017 law changed a lot the situation. So also try to coordinate a little bit more the approach of several institutions in the country. But as you might know, Italy does not have a centralized government. So we also have regions, and within regions there are some important competencies with regard to minors and age assessment. For example, the healthcare is regulated at the regional level. And so also the role of doctors, professionals is regulated by regions. So we witness many differences between one region and the other. What is quite also, an important innovation is that in 2020, so after a while, but then after a few years was finally implemented, in 2020, a protocol was adopted for the determination of the age of unaccompanied minors. And in the protocol, we really find some details as for the exact procedure to follow. And after 2 years, I can say that there are still flaws, there are still problems. So I cannot tell you that the application of the protocol is equal in all the regions, but there have been quite a lot of efforts to implement this protocol. And what that the protocol says, basically it indicates that the age assessment, so this multidisciplinary approach, should consist of 3 sequential and incremental phases. First, a social interview, then a psychological or a neuropsychiatric assessment, and then, only as a 3rd step, a pediatric examination using the least invasive method possible, which it still is the X-ray of the wrist. So that's the main instrument used. But that's the only last one. So as we will see in a moment, when based on a social interview and psychological or neuropsychiatric assessment, there are no doubts, so the age can be determined, the procedure should stop. And in any case, at the end of the examination, a final multidisciplinary report has to be compiled, so has to be adopted. And in the reports must include the estimated chronological average age with the indication of the margin of error. And the margin of error should take into account both a biological variability, so what is inherent to the biological development of the child, but also the margin of inaccuracy of the system. And so normally, but I can say quite for sure that that's the margin of error generally applied in Italy. It's between plus minus 2 years old. So normally the age assessment identify the age of someone as, let's say, 18 plus minus 2 years. And that means that in this case, there is a presumption of minor age. And so the person can be identified as minor. And so it's quite, there are quite a lot of guarantees from this point of view. And I must say that based, at least in our region, in my region, or at least in the north, I must say that right now, in all age assessment, there are these indication of the margin of error. Just very few last points, because then I want also to leave a little bit of time for discussion. These protocols also explicit define what should be understood as safe environment by stating that the age assessment can only take place in the center where the minor is housed, so in the reception center, or in a public health facility. So it cannot take place in courts, it cannot take place in, for example, police stations, so only in these two places. As for the professionals, they are identified as being pediatricians with oxological skills, psychologists or a neuropsychiatric, a child neuropsychiatric, and the social workers. All these professionals has to be appointed. They have to be professional coming from the National Health Service system. So they have to be public professionals. They cannot be a private one. Then there is a cultural mediator, which is a slightly more complicated issue, because normally cultural mediators are still appointed, nominated by the reception center, so by basically private organization, whereas in some region, especially in the northeast, yes, there is a very good practice according to which cultural mediators are appointed by the national health system. Of course, the problem is funding, but I mean, it's also the decision has to be taken according to priorities, and in the region in the north, so some funding were basically devolved mainly to this to implement this role of cultural mediator. And finally, and we are I'm almost at the end of the presentation, some procedural guarantees that were once again provided for all minors, so not just for asylum seekers or victims of trafficking, and this is very important. So basically the law states that minors should be informed in advance before starting the age assessment of the content of the procedure, of the possibility to refuse it, and what is more important is that the law explicitly impose an obligation to inform the minor in a language he or she can understand. Also, the way we have interpreted this provision does not only comprise a language as the spoken language, so of course it has to be in a language that the person understands, but also as the style of the language. So it should be avoided all legalistic technical terms. So there are some information lifted that were developed using a child-friendly language. And that was also quite important. They are not always used, I must say, but in some situations they are actually used, and that's a good practice as well. And then as for the right to legal representation, the law also clearly states that the person, we already talked about the right to be appointed with a guardian, but he or she also has the right to nominate, so to appoint a lawyer. And what's more important is that the power of attorney to the lawyer can be conferred both by the guardian, but also directly by the minor, especially because the idea is to provide all the guarantees, especially in those situations in which the guardian has not been appointed yet. And then finally, the final decision. So we have seen that after the age assessment, multidisciplinary report is adopted. The report is then sent to the court, and the court issues a decree, legal decision stating the age of the child. That decree can be appealed within 10 days at the higher juvenile court, so always within the juvenile system. And of course, the child has a right to be assisted by a lawyer free of charge. So this is more or less the framework, the Italian framework on unaccompanied minor protection, reception, and age assessment procedure. I'm not sure whether or not, no, I didn't put in the slides the link to this 2020 protocol, but there is also an English version. Here you can see some of, I took some images from the protocol. And so you have, I have summarized the main steps of the age assessment. So you can see documentation, observation, and then multidisciplinary age assessment through a social path and a psychological and neurological path. If there are sufficient elements, the joint report is adopted. Otherwise, the pediatric examination has to be carried out. And finally, also a joint report is adopted. But I can send you the link to the protocol because you can find in English all this information. And then right now, just to wrap up and to in order to give you the floor for any questions, and then we can discuss some cases. But I wanted to point out to some of the main persistent challenges that we face nowadays. So even though the law is positive, challenges still remain. In my opinion, one of the main problems is the delays in the procedure. Because of course there are also many guarantees, but at the same time, the juvenile courts are quite full of this proceeding. And so it creates many delays in the decision, and it's problematic, especially for those minors who are 17 years old, for example. We have many cases of minors who are 17. The age assessment procedure starts, and then it takes, for example, 5 to 6 months. And in the meanwhile, the person turned 18. And of course, it's important for his or her identity to be identified with that certain date of birth. But so because of the length of the procedure, you cannot have access no more to all the safeguards and protection and to the protection system he should be entitled to. And then secondly, well, the other challenges are somehow all interconnected, because we often witness this unlawful practice on the part of police authorities to determine the age of migrant immediately after disembarkation, immediately at the border, especially at ports. And it happens especially for certain categories of minors, for certain categories of third country national, and namely for those who come from certain countries, such as Morocco and Tunisia, mainly because there are some readmission agreements with those countries, so it's easier to return those migrants. And so for minors coming from Tunisia, especially, the age assessment is not always, so the formal procedure for age assessment is not activated. The age is determined by the police, so that adults, so those minors who then are identified as adults can be issued with expulsion order, and sometimes they are also detained in pre-removal detention centers. And once they are in detention centers, it's much more difficult for them to activate the age assessment procedure. So I've been following some cases. In some situation, once the minor wanted to activate the procedure, he was then released from detention. In other cases, minors were kept in detention, unlawfully of course, but they were kept in detention during the procedure. And only at the end of the procedure, once they were actually identified as minor, they were released. So this is still quite a problematic issue. And finally, detention in hotspots. I think you are quite aware of this hotspot system, hotspots facilities. They were implemented in 2016 in Italy and Greece. And since their implementation, it's still not quite clear whether or not they are detention or reception centers. They can be both, depending on the situation, depending on the period. But it happens that minors were de facto detained because it was not possible for them to leave the detention centers. This happened a lot during 2016-17 in Taranto hotspot, for example, in the Apulia region, so not on the islands, but on the mainland. And it's happening right now. It happened this summer in the Lampedusa hotspot, so on the small island in the middle of the Mediterranean. And because sometimes it used to happen more in the past than now, but especially in the past, authorities wanted to carry out the age assessment procedure in hotspots, but they didn't let migrants to leave the hotspot until the end of this identification procedure that include, in some cases, age assessment. So that meant that minors stayed for several weeks, even months, in hotspots. And then, we had to face these issues of detention of minors in quarantine ships, but it was only for a brief period. So quarantine ships were those ships implemented, so used between 2020 and June 2022, so they are not in force anymore. But at the beginning, they were used to, for migrants in general, to spend a period in quarantine. And at the beginning, also minors were had to spend a period in the ships. But then with several violations of their rights, because they did not have, it was impossible to appoint a guardian, they didn't have access to all the procedural safeguards. And so this practice was eventually, it was ended by the intervention of some juvenile courts. So this is, again, an overview of the persistent challenges in Italy. I stop now. And it's almost, we don't have much time, but maybe instead of going through the case studies, we can just open up the floor for discussion. Of course, if you have any questions about the Italian case, Italian procedure, I'm happy to answer to all your questions. but also if you have any consideration, any evaluation to make, and for example, about the differences of similarities between Italian and Polish situation, I'm very happy to hear your voices. Thank you very much for the attention.
Proszę Państwa, jest czas na zadawanie pytań. Można zadawać też na czacie. Będziemy czytać. Thank you for your lecture. Yeah. Okay. Can you hear me or?
Yeah.
Okay. Thank you. So thank you very much, or grazie mille per la tua lezione. And I had one question for now. I was interested in those guardians, those new volunteer guardians that came into life as an institution in Italy. Do they have any kind of state support? Some kind of, I don't know, translator support or financial support when they are taking care of the minor, or is it pure volunteer? They must do everything by themselves.
I'm happy to answer this. Do you want to collect some questions, or should I just answer this one and then we move forward?
Can answer the questions.
Okay, yeah, that's quite a problem indeed. So the way the law imagined in 2017, it also envisaged for a fund to at least pay some of the expense, to cover some of the expenses of the voluntary guardians. That was never implemented until this year. And then this year, they actually provided this fund, they activated this fund. So right now, voluntary guardians can apply for some, let's say, payback for their expenses. But yeah, it's mainly it's on a voluntary basis. So, I mean, I must say that in Italy, also in general, many services provided to migrants run on a voluntary basis, so on charity and so on. And so this is quite a problem, because indeed it's, for example, I know many guardians that accompany the minors from one city to another. For example, when they have to find some documents, apply to some documents to the consulate or to the embassy, they have to go all the way to Rome, basically, because most of the embassies are only in Rome. And so they pay by themselves, which is, I mean, very, very, it's great on their part, but it's problematic because they should be supported. So in theory, yes. In practice, only after 5 years, this fund was actually implemented.
Just one question. You mentioned about the right of the child, and you said that the child should give its consent for the to be subjected to examination. So what would happen if the person or the child refused to be subjected to such age assessment or examination?
That's a good question. I personally, as a lawyer, never experienced that situation. In some cases that I recall, at the beginning, and once again, I think this makes clear how important is cultural mediator, because at the beginning, the minor didn't want to undergo this procedure, so he was not convinced. But then by speaking with him, by explaining with him all the guarantees, how the procedure would have been, then he eventually agreed. So, but I guess, yeah, I guess probably, well, I don't know whether or not court can ask for a, can issue an order to impose that, but I don't think so. So basically, the court determine one age without conducting the entire age assessment. And it's normally, I would say, the age identified by the police at the first contact between the child and the police. And then the person is still able to, can still appeal that decision. I think that's the way it should go. But in my experience, it never happened.
In Poland, refuse, you are adult.
Sorry?
In Poland, it's very clear. If you refuse the examination, you are considered as an adult.
Yes, I mean, I think the initial date of birth, which is the one that has been registered basically when the police register the person, is the one that remains. But I think connected to this, we had quite an interesting case. It was not a refusal to undergo an age assessment. So let me, but it was a situation in which the interest and the will of the minor, actually not even the minor, but this individual, this applicant used to be a minor and then he turned 18, but the prosecutor at the juvenile court insisted on conducting the age assessment. Okay, here we are, is this case study, which, yeah, I think it's quite interesting. If you want, I can read it out loud for everyone. So basically, this child, he arrived in Italy when he was 16 years old, was accommodated as a minor, he applied for asylum, he was recognized as a beneficiary of humanitarian protection, which is a national protection. So after 2 years, it was a few months before he turned 18, he was moved into an integration reception facility, so the second stage. So basically he stayed 2 years instead of 30 days in the first reception facility. Then he was moved in the north, so in Piemonte, in our region. And shortly after his arrival, the prosecutor decided to activate an age assessment procedure. The result of the age assessment showed a date of birth compatible with the one declared by the person. So it was 1st of January 2001. And in the meanwhile, he reached 18, so he was not a minor anymore. The margin of error in this case, because it's a case of some years ago, I think it was 2017 or something. So it was some years ago, the margin of error was plus minus 1 year instead of 2. But according to the margin of error, it was possible to consider him as a minor, because it could have been either 17, 18, or 19 years old. And the prosecutor appealed the decision of the court, claiming that in the light of the best interest of the child, and based on the margin of error, the date of birth decided by the court should have been fixed at 1/1/2002. And so I'm curious to ask you, what do you think about this case? Who do you think, what do you think are the rights at stake here? And for lawyers, for example, what would you do in this case, in this situation? I don't know if anyone wants to comment on this. Not quite. So if there is no one, I can, well, basically give you the final, the outcome of the procedure was that the prosecutor appealed the decision, and then we assisted the person, and we claim that he has right to self-identification. So even though, so here you can see that it's also sometimes it's not easy to define, to understand what is the best interest of the child. So is it in his best interest to be identified as a minor and therefore have access to reception for minors, so many more guarantees, or is in his best interest to basically to accept the self-identification that he made. So this person, he grew up convinced that he was born in 2001 and not in 2002. And he insisted on this. And so basically, yeah, we represented him. And in the end, the Court of Appeal judged in his favor. So stated that it's, well, actually, in the meanwhile, during the proceeding, he also acquired a passport from his country of origin, so it was quite clear because with a document there was no doubts. But the court of appeal underlined that it is in the best interest of the person to actually listen to his voice, to allow him to self-identify himself, and not to impose on him some other different date of birth, just because for the authorities it was better. So yeah.
About the case study, please tell me why they ask they start this age assessment procedure after 2 years. Something happened, or because it's like, you know, somebody decided? I was wondering why after 2 years they decided to do this.
Yeah, basically, as he was moved from the south to, so he changed the accommodation, the reception center. The social services of the town in Piemonte, they spoke with him and they decided that it was in his best interest in order to allow him to stay basically 1 more year in the child protection system. And so they thought, okay, it might be in his interest, it might be better for him to extend of 1 year the accommodation. And so they wanted to do something in his favor, basically. But yeah. So sometimes like they overdo it too much. No, but it's important to understand that the minor, the person, the individual has to be, and we stress that this point also, I remember in many of our project webinars and trainings, it's important to hear the person, to hear the voice, the view, and the needs of the person. And I can also, on this point, I just wanted to underline that there are some, I think you already have them, but there are some training modules, especially on the rights and the importance to the right to be heard of the children in the proceeding, and the way to communicate with children, which is very, very much important in this kind of procedures. I think I put okay, yeah. So in this slide, you have the link for all the training modules. Oh, no, go ahead.
I have a general question. How many minors, unaccompanied minors, do you have in Italy?
That's a good question. I have recently, let me find out, because I have recently read a report on this. So on the first 6 months of 2002, let me find that out, but I think it's just a sec. Okay, I try to, are you still, can you still see my screen? No. Okay, let me
What
share.
happened to the PowerPoint presentation?
Let me, okay, I'll try to share it, because I found there is this interesting report. I think there is a brief summary in English if you want. Okay, can you see it now? So you can find it on the European website on integration, and there is a report on unaccompanied minors. And so as of 30th of June, there are 15,500 unaccompanied minors. And as I told you at the beginning, there has been a huge increase in 2022, because there are some data also on country of origin. And so they arrive primarily from Ukraine. So 5,000 minors coming from Ukraine, and then Egypt, Albania, Bangladesh, and Tunisia. What about Poland, if I might ask?
And unaccompanied minors. I think last year we have 100. Yeah, so it's much higher than it was in the previous year. In the years, like in 2020, I guess it was like around 15 unaccompanied minors.
Okay.
Yes, so the number is not high, as you can see. But we have a problem with the age assessment, as you know, that the Polish authorities only do the X-ray of the wrist, and this is all. You cannot make an appeal from the certificate about your age. So we got some reports that in detention centers are minors, because they couldn't confirm they are in any way. They didn't have any documents and so on, but they were telling us that, you know, that they are under the age.
And oh yeah, sorry. I cannot hear.
Eva was referring to unaccompanied minors that don't come from Ukraine, because in Polish system, we have like those double standard. We have the new special act that applies only to the citizens of Ukraine. So those 100 unaccompanied minors regard only those that do not have Ukrainian citizenship. And as for Ukrainians without like parental care in Poland, they are probably like close to 100,000 people, but they are not like, you know, their situation is different from the legal point of view, because they do not undergo those procedures of accompanied minors. They just get to legally stay in Poland automatically.
Okay, yeah, it was also quite an issue in Italy, because we have all this legal framework, and I mean, it was quite difficult to make a distinction. So to say, okay, Ukrainians, they are not subject to the law, whereas all the other minors should be subject. So courts are still trying to find a balance, because of course then there are not most, but many Ukrainian minors, they also came with tutors, or they are accommodated within families. So the situation is quite different as from minors coming from Libya, so Bangladesh, or also Tunisian, Ivory Coast, Guinea, there are many coming from Libya. So the situation is different, but at the same time, you cannot decide not to apply like the law to these groups. So yeah, a balance needs to be found, I guess. But just to comment on Eva's comment, I don't know if you, because also in Italy, there was this situation and difficulties and unlawful age assessment procedure. And it has been quite important, in my opinion, the fact that one case was brought in front of the ACTHR. So you might be familiar with that. That's the Darboe case. It's a case brought in front of the court in 2017, and then it was decided in 2022. So a few months ago, it was July 2022. So it's basically the case study I wanted to discuss with you. The first case study, it's basically the Darboe case. And so in that, for this case, the court actually in 2017 already ordered to the government to move the children from the adult facility to a specific facility for children. And then this year it ruled that the unlawful age assessment, so with no margin of error and without any proper information provided to children, amounted to a violation of Article 8. So I know, it's complex to go in front of the ACTHR, but that might be, a remedy that you can also try.
Darboe and Camara case?
Yeah, that's it. I'm not sure whether or not I put the link to the case in the slide, but I can do it. And then when I share the slides with everyone, you can find it. Okay. So I don't know if you have any further questions. Of course, happy to.
Any last questions? So there are no questions in the chat. So thank you very much for the presentation. I guess that we will ask you some more details about the HSN in Italy in the email. So thank you once again. Have a nice day.
Pleasure. Thank you very much. And I will send you, so I will send you the slide with a link to the protocol. So just in case maybe you want to, bring forward some advocacy on age assessment, you can use these protocols. Which might be
great. Yeah. Thank you very much. And have a nice day.
Thank you, you too. Have a nice weekend.
Bye.
Bye.
Chyba będziemy kończyć nasze spotkanie, nasze szkolenie. Bardzo dziękuję Państwu za udział stacjonarnie i online. Mieliśmy bardzo dużo uczestników. Mam nadzieję, że Państwu przydało się te informacje, które były tutaj przedstawiane. Na czacie, również w mailu podsumowującym wyślę Państwu jeszcze raz link do tych wszystkich materiałów, które zostały wyprodukowane w czasie trwania naszego projektu, jak również chciałabym dać Państwu znać, że te nasze szkolenie było nagrywane i będzie również udostępnione na naszych stronach. wraz z tłumaczeniem i transkrypcją, więc można się z nim zapoznać również w okresie późniejszym, jak ktoś będzie chciał coś sobie powtórzyć albo sobie coś przypomnieć. Więc jeszcze raz bardzo Państwu dziękuję i do zobaczenia.